My name is Emily Hendrickson, and this is the Week 2 discussion about the Full Faith and Credit Clause. So what exactly is it? The clause outlines that state courts must respect and uphold the decisions made by other state courts. Without recognizing and upholding other courts' judgments, individuals could avoid final decisions by moving to a different jurisdiction, ultimately weakening the justice system's authority. Fearing this issue, the Founding Fathers admitted the clause to the Constitution. Where is it located? The Full Faith and Credit Clause is located in the first section of Article 4 of the U.S. Constitution. And then some simple examples. If a couple gets married in Kentucky, their marriage is recognized and valid if they decide to move to Maine. The second one is a Colorado driver's license is valid in all other states. And then the third one, a lawsuit judgment issued in a Florida state court is also upheld in a Georgia state court, meaning that the debtor cannot go to another court in hopes of receiving a different outcome. So the case that I decided to analyze was Joan Blackwell versus Zachary Grady, and this was posted in 2024. So as a brief introduction, on October 4th, 2021, Erin Jo Baker was driving on Interstate 81 in Rockbridge County, Virginia, in the very early morning hours with her fiancé Zachary Grady and their two daughters aged 1 and 3. They got into an accident and came to rest in the left lane. Grady exited the car and got the daughters out, but Baker's door was jammed shut, barring her from exiting from the driver's side. As she tried to climb over to the passenger side, a large tractor-trailer driven at high speeds by Daniel Rothwell slammed into the back of their car, critically injuring Baker. She was medevaced from the scene, but unfortunately succumbed to her injuries later that day. She passed away in estate, meaning that she died before writing a will. A couple weeks later, Baker's parents each signed a form giving Grady full administration of Erin's estate in Pennsylvania. The case begins on February 14, 2022, when Blackwell, Erin's mother, was briefly awarded as administrator of estate under Code of Virginia Section 64.2-454, which states that appointment of administrator may be given for prosecution of action for personal injury or wrongful death against or on behalf of estate of deceased resident or non-resident. While she was Baker's administrator of estate, Blackwell filed a wrongful death suit against Rothwell and his employer La-Z-Boy Logistics, Inc. Grady knew of Blackwell's appointment as administrator by March 10th, but did not refute it until a year later. On March 22, 2022, Grady filed his own wrongful death suit. Nearly a year later, on February 3, 2023, Grady filed a petition to bar Blackwell from pursuing her wrongful death suit on the basis that she had previously renounced her rights to administrator in 2021. While this should have been plausible, Code of Virginia 64.2-454 states that there is a 6-month statute of limitations to appeal an appointment, meaning Grady's petition would not be valid. Thus, the court upheld the rules and limitations of Virginia law and dismissed Grady's appeal to remove Blackwell as administrator. So what does this case even have to do with the full faith and credit clause? This case concerns the full faith and credit clause because Grady's entire argument relied on the fact that the clause, quote, required Virginia courts to enforce Blackwell's renunciation in Virginia, quote. If the Virginia Code 64.2-454 had been written without time constraints, the Virginia court would have had to respect the initial Pennsylvania renouncement of Blackwell as administrator of estate. However, Grady's challenge was deemed untimely as the 6-month statute of limitations had already expired, and the court affirmed that Blackwell was entitled to administer the estate of Erin Baker and pursue her wrongful death suit. And then these are my references.